Good morning, guys. Well, it might be evening actually for a lot of you. Starting really early this morning because we've got a lot to get through and we've got a lot coming to join us on the docket, which I'm going to try and get through. So we are now moving on to Blake Lively's Talbot motions. And I'm going to start with this one. So this is on this one, she's looking to exclude the testimony of Michael Wagner. I won't talk too much about it. We'll just read. Plaintiff Blake Lively respectfully moves to exclude the testimony of Michael Wagner, an inactive attorney and accountant who intends to offer a potpourri. What? Who intends to offer a potpourri of opinions about inter alia the law, social media manipulation, and Hollywood acting careers. I wonder. I'm just going to go and see who's written this because it feels like it's Gottlieb trying to be funny. It doesn't say. Although I have seen Ezra Hudson do the sign off on the declaration. So it could be her, and she is also not funny. Wagner is not qualified to offer any of these opinions, and even if he were, they require exclusion because they invade the province of the court, will not help the trier of fact to understand the evidence or to determine a fact in issue, and are not reliable. Rule 702 of the Federal Rules of Evidence and Dalbert. There we go. So you're going to hear the same thing, like, well, you should exclude them for these reasons, and even if you don't, it should be excluded for these other reasons. It's going to go along the same sort of line as Wayfarer's Dalbert motions went for Lively's experts. So, background. Defendants intend to offer Wagner to rebut Lively's experts. Brand damages expert Jeffrey Kinrick, a certified public accountant with more than 40 years of experience analysing damages in commercial disputes. Richard Marks, an entertainment transactional lawyer who has been practicing for over 50 years. Michael Sipple, a CPA. Is that a certified public accountant who has worked in the entertainment industry for nearly 20 years? And Dr. Ashley Humphreys, a professor at the Medill School of Journalism, Media and Integrated Marketing Communication, Northwestern University, who holds a PhD in marketing from the Kellogg School of Management at Northwestern University with a focus on cultural sociology. Opinion 1. Legal standard. Wagner intends to rebut Kinrick's opinion that Lively suffered losses between $38.6 million and $143.5 million, representing her share of the lost profits of her two businesses, Blake Brown, a hair care line which is owned by Family Hive, and Betty Booze, a ready-to-drink is this an advert for Betty Booze? A ready-to-drink alcoholic beverage and mixer company which is owned by Betty B. Holdings, by opining that she lacks standard to recover damages associated with her brands. He plans to testify that any damages related to lost profits and lost royalties calculated by Kinrick are not properly included as damages to Blake Lively as opposed to Blake Brown and Betty Booze. While the amount of profit that Blake Brown lost due to the alleged retaliation campaign could conceivably be considered lost profits to Blake Brown if Blake Brown had standing in this case, that lost profit amount is not lost profits or damages to Blake Lively. So that's a little quote, and that's a quote I fully agree with as well. Opinion 2, online manipulation. Wagner challenges all four experts' damages analysis on the basis that another Wayfarer expert, Nicole Alexander, concluded that defendants were not responsible for negative online commentary about Lively. Wagner also relies on his own bold claim of allegedly unrelated negative press about Lively from January 2023, when it was announced that she was hired for the role through early August 2024. But it is undisputed because Wagner acknowledged in his deposition that he did not actually perform any analysis. He admitted that, aside from reviewing the complaint and collecting examples of press from public articles, he did nothing else to reach his conclusions. He did not apply any methodology and did not attempt to quantify damages. His opinion was purely an assumption. Opinion 3. Brand underperformance. Wagner opines that even if some small amount of revenue or profit was lost by Betty B or Blake Brown, Kinrick's analysis cannot reasonably and reliably estimate the amount of lost revenue or lost profit, and his methodology significantly overstates the potential amount of lost revenue or lost profit. In support, Wagner points to a number of alternative factors that could have caused the decline in sales, without actually analysing whether they did impact sales. I quote him, "I have found a number of reasons why the Blake Brown products sales could have been affected from July 2023 through the period that Ms. Kinrick calculates damages." He also claims that Kinrick's damages estimate for Blake Brown is based on an unrealistic financial projections, despite later admitting that the product outperformed even the highest projections. Opinion 4. Acting damages. Wagner intends to rebut the opinions of Marks and Sipple, who conclude that Lively suffered damages between $34,300,124 to $87,793,592. There's a discrepancy there, by the way, of close to $50 million, which is nuts. In lost acting, endorsement, and speaking opportunities based on Miss Lively's career trajectory, and the enormous success of It Ends With Us. By opining that Lively would not have suffered damages because of this magnitude because, 1, her ability to accept acting or producing opportunities at the same time as her husband is constrained, including because her husband is the second highest paid actor in the world. 2, the amount exceeds what Lively earned on projects in the past. And 3, Blake Lively is going to get more acting and producing projects in the next 5 years than she has to date. To the extent Wagner offers any support at all for his conclusions, he cherry-picks facts and ignores contrary evidence. So did Lively's expert. That's what... experts do that. Opinion 5, reputational harm. Wagner opines that Humphrey's damages calculation ignores the large amount of free positive publicity that will occur if Blake Lively wins this lawsuit, which will obviate the need for and cost of a reputational repair campaign. Legal standard. Federal Rule of Evidence 702 provides that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise only if a. the expert's scientific, technical, and other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B. the testimony is based on sufficient facts or data. C. the testimony is the product of reliable principles and methods. And D. the expert has reliably applied the principles and methods to the facts of the case. Pursuant to Rule 702 and Dalbert, a district court must ensure that any and all scientific evidence or evidence admitted is not only relevant but reliable at every step. So their argument is now, Mr. Wagner is not qualified to offer opinions 1, 2, 4, and 5. Wagner cannot meet the threshold requirement of demonstrating that he is qualified as an expert by knowledge, skill, experience, training, or education to offer any of the opinions. Wagner is an accountant. He is not a practicing lawyer, a data scientist, or an entertainment industry professional. He therefore cannot opine on Lively's legal standing to recover damages related to her brands, which invades the exclusive province of the court regardless. He cannot opine on whether defendants engaged in online manipulation, and in fact relies almost exclusively on Alexander's conclusions, all of which are subject to a separate Dalbert attack, and which did not reach any conclusion as to whether defendant's conduct caused the extraordinary spike in the online conversation about Lively in August 2024. Mr. Wagner cannot opine on what kind of action, endorsement, or speaking offers Ms. Lively could have reasonably expected to receive following the success of the film because he lacks any experience as entertainment industry professional, a reality that is underscored by the fact that he relies on yet another Wayfarer expert, Emmanuel Nunez, to arrive at this conclusion. And Mr. Wagner cannot opine on whether prevailing in this lawsuit would restore Lively's reputation, that she would not need to incur the cost of a repair campaign because he possesses no expertise on how the media ecosystem operates and gives no indication that he reviewed, let alone could understand, the data underlying Dr. Humphrey's opinions. Without any relevant professional experience or case-specific knowledge, Wagner cannot offer opinions 1, 2, 4, or 5. Opinion 1 is an impermissible and incorrect legal conclusion. Opinion 1 is pure legal conclusion on a question of law, the scope of recoverable damages for a particular plaintiff, and thus an improper subject of expert testimony. Okay. Defendants cannot dispute that opinion 1 is a legal opinion because they advance the same legal argument in the summary judgment motion. Rule 702 does not permit the Wayfarer defendants to present a disputed legal theory to the jury by laundering it through the authority of an expert witness. Opinion 1 requires exclusion because it is unhelpful to the trier of fact, and presenting a legal argument via an expert rebuttal would confuse the respective roles of court and jury and risk verdict error. Mr. Wagner's legal authority is inapposite. Even if Wagner could offer his opinion on standing, his sole reliance on a single out-of-circuit patent case, Mars, does not support his opinion. Wagner cites to Mars to argue that Lively cannot recover her apportioned share of Family Hive and Betty B's lost profits because they would not inexorably flow to her because her ownership interest is held via another entity. But Mars addressed a narrow fact-specific issue, whether a parent company could recover lost profits damages in a patent infringement action for sales lost by its wholly owned subsidiary. There, the federal court held that MEI's profits did not flow inexorably to Mars, based on a highly case-specific and fact-specific conclusion that the entities were linked only by a royalty-bearing license agreement under which MEI paid royalties to Mars, not by any profit sharing. Here, unlike the arrangement in Mars, Lively was entitled to receive any profits through the entity that she controls and which owned a percentage interest in each of Family Hive and Betty B holdings. Mars is thus inapposite, and Mr. Wagner cannot use it to support his already inadmissible opinion. See, I don't agree with that argument at all. I stand quite firmly in my own belief that yes, there are some circumstances where there is an exception to the rule, but an individual and a corporate entity, even if they are the sole shareholder, it's just not an interchangeable situation. It's not, because because it's a legal standing. It's a question of legal standing and status. The entity has its own kind of, obligations. It has to adhere to the law. It has its own rights, separate and distinct even to an individual. So no, I'm not convinced by this argument that, even if there's case law to support it, I think there will be more case law in this particular scenario to rebut the presumption. But I don't think that Lively should be able to sue as an individual for losses that her entities suffered. And that's if she can prove they actually suffered them. Mr. Wagner's opinions are unhelpful and irrelevant. Well, no, they're not helpful to you, are they? Wagner's opinions are unhelpful and irrelevant because they parrot the opinion of other experts without any independent thought and rely entirely on conjecture and assumptions. For example, opinion 2 relies on adopting Alexander's conclusions wholesale without any independent analysis of her conclusions or underlying data, and on assumptions he accepted without any scrutiny. His concession that he did nothing to reach opinion 2 did not apply any methodology and relied only on what he claims without any analysis was a handful of unrelated news articles is fatal. The same holds true for Wagner's opinion 3, which points to a variety of potential alternative factors that he opines could have caused the decline, but does not conclude if they actually did cause the decline in sales. For example, Wagner intends to testify that Blake Brown product line may have performed worse than expected. It would not be surprising for customers to try the Blake Brown products and then move on to other hair care products, which they did. That's exactly what happened. And it would be expected that Miss Lively would be a much more effective influencer and promoter for the non-alcoholic beverages that Betty Buzz sold. None of Wagner's conjecture about what could have caused the decline in Lively's brand sales will help the trier of fact to understand the evidence or to determine a fact in issue, many of which require no expert analysis at all. Opinions 2 through 5 are unreliable under Rule 702 B to D. Opinions 2 to 5 require exclusion because Wagner must but cannot show that they rely on sufficient facts and data and reliable principles and methods, which means that the data sample must be adequate, the data gathering techniques reliable, and the conclusions drawn demonstrated to be statistically significant. In opinion 2, Wagner does not even attempt to address the copious amounts of evidence. Copious amounts of evidence. That's interesting. Adduced in this case, showing that defendants engaged in an online digital manipulation campaign. That's a PR line. Wagner instead concludes the opposite, based in his opinion on a handful of online articles that he collected without any principled process for doing so, claiming, without performing any analysis or applying any methodology, as he conceded in his deposition, that they have no apparent connection to defendants. He comes to his conclusion despite the fact that some of these articles reference the very same themes defendants expressly stated they would advance against Lively. Wagner's reliance on nothing more than his say-so does not suffice. At best, opinion 2 is rank speculation. At worst, it is flatly contradicted by the evidence. Either way, it must be excluded. Yeah, I don't think that's getting excluded. I don't think they're arguing well enough here. They don't like his evidence. It doesn't help them. That's all I'm hearing. I'm not actually hearing any real basis for excluding the expert. As discussed above, opinion 3 amounts to speculation about potential alternate causes for decline in sales without any attempt to apply these theories to the facts of this case in any meaningful way. As if to underline this point, Wagner does not even attempt to offer an alternate damages calculation, instead merely opining that Kinrick's estimates are overstated. This is not a methodology, it's an inadmissible thought experiment. Opinion 4 is equally untethered to the facts of the case. In concluding that the opinions of Marks and Sipple overstate the number of projects she would have completed in the 5 years after the release of the film, Wagner ignores testimony that Lively was committed to working full-time after the release of the film and was ready to capitalize on its success. Wagner instead substitutes a moralizing and outdated view of marriage for the reasoned analysis, asserting that because Lively's husband is far more successful than Blake Lively, the married couple is far better off the more Ryan Reynolds works than if Blake Lively works. Now, you see, to say that she was ready to capitalize on its success, there are text messages between Ange Giannetti and Sanford Panage from Sony, which says she is going to retire. Now, where they've heard that from, I don't know, but it's in the messages at the time. Not only that Blake Lively was going to retire, but there's also messages saying that Ryan Reynolds was planning to retire for a bit as well. So where's the capitalizing? The plans to capitalize? Because there is evidence in, well, there are certainly beliefs. Now, technically, they would be probably inadmissible for hearsay, but it's a point that could be put to Lively, and she could be questioned on that. Like where, and I think Ange Giannetti is a trial witness, so she may be able to speak to where that what happened in that conversation, where that belief came from. Did it come from Lively? That may make a difference. Was anyone else aware? Did anyone else have the belief that Lively was planning to retire? Who knows? Okay. Wagner instead, I'm just going to go over this bit again. Wagner instead substitutes a moralized and outdated view of marriage for reasoned analysis, asserting that because Lively's husband is far more successful than Lively, the married couple is far better off the more Ryan Reynolds works than if Blake Lively works. If the guy is the second highest paid actor in the world, which I'm not convinced he earns that much, but he's certainly a very, very, very highly paid actor. If he is earning, he's quite a prolific, actor as well. He does churn out film after film after film after film. If he is now able to command, say, I don't know, 20 million, 30, 40, 50 million dollars a film, Lively got paid $1.75 million for It Ends With Us, and that was her biggest film to date. She got paid more for Another Simple Favor. We now know this, but it's not going to be drastically. It's not going to be in the tens of millions. So although people may not like to hear that the husband would, that the couple would earn more money if the man was working, but in this case, that is quite literally the case. It's not a sexist view. He is a higher earner. He commands more money because he's had far more success than her, not because of any gender. It's not because of that. He is, I hate having to say this, but he's a better actor than she is. He's far better at acting than she is. And as much as I don't like the guy now, he can, whilst he was awful around the marketing with It Ends With Us, you can't say that he has not done well in marketing Deadpool. So I have to give credit where credit is due, and it is not a misogynistic thing to say that, or what was it they put? An outdated view of marriage. It's not about the marriage. It is literally how much does he earn per film, and how many films does he do? How many projects does he juggle? And his net worth is, before this case, Lively was worth around 30 million. Ryan Reynolds was worth, over 300 million. That's 10 times more, because he's not only been more successful in his acting career, he owns, various entities and shares in entities like Mint Mobile, like Maximum Effort, like Aviation Gin. And he has made huge successes of them, where Lively is juggling a couple of businesses which are failing. Betty B was not doing well back in 2023 when it had Betty Buzz. It was not doing well. That is in one of the expert reports. So I don't like. I hate these kind of virtue signaling kind of. Oh, you're being misogynistic because she's so basically what Lively's team are doing here are saying, well, you're saying that she's not going to earn as much as her husband because she's a woman. That's absolutely not the case. She's not going to earn as much as her husband because that is not her command. That is not her star power. And whilst it may feel a little bit unfair, it's also a reality check, because that is a fact. She just does not, even when she gets a role in a film, she cannot ask for tens of millions. She won't get it. Ryan Reynolds could, and probably does. So to say that, they are financially, they're better off the more Ryan Reynolds works than if Blake Lively works, is actually a fact. It may be one that feels unfair. It may be one that she does not want to hear, does not like to hear, but it is not. You can't just avoid saying things, and just because people are uncomfortable with that. Wagner misunderstands the nature of the offers Lively has received since the film's release, claiming that Lively will be paid on a development deal for which no fee is guaranteed. And then, right, hold on a minute. If she's had offers, then why hasn't she taken them up? Then surely this contradicts their argument that she's lost opportunities. Because if she's received all these offers, then she hasn't actually lost anything. If she's chosen not to take them, then she's not mitigating her losses. Right, okay. Look, I'm gonna let that bit marinate a little bit. Wagner misunderstands the nature of the offers Lively has received since the film's release, claiming that Lively will be paid on a development deal for which no fee is guaranteed, and incorrectly asserts that Sippel's analysis fails to account for events that occurred after the alleged retaliation. Mr. Wagner further opines that Marx and Sippel failed to take into account the effects of the 2023 Writers Guild and SAG strikes, while ignoring testimony from actual Hollywood professionals that the strikes in fact increased the draw of A-list talent like Lively. I mean, I wouldn't call her A-list. Her husband's A-list, but she's not. Right? But the Writers Guild strikes should not have affected her at all. And it really annoys me, actually, that they're even suggesting that affected it. It would have affected Ryan Reynolds, but not Blake Lively. So, actually, I've got the website here because I did a whole thing on the unions and the rules and what rules were likely breached by Blake Lively, by Justin Baldoni, by Ryan Reynolds, and by Sony and Sean Levy even in this whole facade with It Ends With Us. But there is the SAG-AFTRA includes a no strike clause in collective bargaining agreements. So if another union like the WGA is on strike, you can't go and strike with them. You can show solidarity in like your breaks and your lunch times and stuff, but if you are, unless you are a WGA member, you can't join the picket line. Now, even if you are a WGA member, if you are also, that just means you can't write. But you can continue to act. So, like Ryan Reynolds, whilst he couldn't have written anything during the WGA strikes, he could have continued to act. It was only when the SAG-AFTRA strikes come in, which downed everyone, not just Blake Lively. But she skipped off to join the WGA picket line, which she had no business doing because she's not a member of the WGA. And SAG-AFTRA expressly say, don't do that. Just here, actually. Finally, and most importantly, we must support our fellow SAG members on every set, even if they have to cross a picket line to go to work. Right? So Lively saying, well, it was unfair, Justin Baldoni, to expect me to cross a picket line. No, you have to. If you're an actress and you are regulated by SAG, and SAG is not on strike, you cross the picket line. They are simply following the advice of their union and honouring their contract. It is not reasonable to expect SAG cast members to risk the potentially enormous personal liability that may flow from refusing to work in the absence of a SAG strike. Please note the WGA contract includes a similar no strike clause. And writers would be bound to follow the same rules as if you are another union, and writers would be bound to the same rules as you are if another union was striking. So, and here, if you are contracted to work on a television series or motion picture that continues to produce while the WGA is on strike, you are obligated by your personal service agreement and the no strike clause in our collective bargaining agreements to go to work. You can continue to audition for work and accept new work if you choose to. So that I just wanted to correct that because I'm annoyed with Blake Lively. But yeah, she's also not on A-list. Mr. Wagner's analysis likewise ignores that Miss Lively's past offers are not an adequate proxy for her future offers because they would not reflect the astronomical success of the film, instead falling back on generalized assertions such as actors do not typically have consistent earnings. In this way, Wagner's analysis would unjustly deprive Lively of the financial uplift that the film's success should have brought her. And Wagner takes a sliver of deposition testimony from Lively's agent out of context to conclude that clearly Blake Lively is going to get more acting and producing projects in the next 5 years than she has to date. Neither Wagner's facts nor his methodology is accurate or reliable. Opinion 5 fares no better. In a perfunctory one-paragraph opinion, Wagner concludes that Lively's reputational harm will be eliminated if she prevails in this lawsuit, which Wagner asserts Humphreys did not consider. Wagner does not provide a single citation to anything to support his opinion, including any reason to believe news of such a victory in this case would reach the intended audience at all or with the frequency necessary to restore Lively's reputation following defendant's retaliation campaign. Without facts or methodology, this opinion must be excluded too. Okay, so is Lively is Lively's counsel arguing that Wayfarer were able to smear her within a matter of days of hiring Melissa Nathan, but if she wins this lawsuit, there's no um there's no guarantee that the news of her victory in the court would reach the intended audience. Are we serious? That's ridiculous. And it's completely contradictory to Lively's own arguments that, within, I think it was 4 days of Melissa Nathan being hired, she was supposed to have, destroyed Lively globally. Um, but not Wagner, sorry. But then they're saying, well, if she wins in the court, no one's gonna hear about it. And that makes no sense. Absolutely no sense. Alright, guys, so that's Michael Wagner. Lively's Dalbert motion to exclude him. I will be back soon with another video on the next expert.